my channel, and this is Law Bridge Academy. Today we are going to understand about res judicata, and we all know it is a most important chapter in CPC. So if we go to the origin, then we know that res judicata is originated from English common law and from the 17th Amendment of the US Constitution. So first in Indian US Constitution it was inserted in 17th Amendment, and it was originally from the English common law, meaning res and judicata. Res means subject matter and judicata means adjudicated, a matter which is already adjudged, available both to civil and criminal law. A matter adjudged, a thing judicially acted upon or decided, a thing or matter settled by judgment. So what is adjudicata means? A matter which is adjudged, a matter which is already judged, or already there is a decision, and a thing judicially acted upon or decided, and or a thing that a judge already go through or decided, then this matter or settled dispute cannot be bring upon the court again. So if you file a suit and it's already adjudged, the court given an verdict on the basis of it, you cannot again, if it is something that you are not happy with the judgment or verdict, you cannot again bring a suit and again challenge it. You have to go through the appeal or any revision or review process, anything, but not you cannot again file a suit on the basis of it. So this is a means of res judicata. So in res judicata, we all know there is the doctrine. In three doctrine, it was basically based. First is nemo debt vis vexere pro unat edem causit, also known as double jeopardy, which means no one should be vexed or punished twice for the same offense, as it is it's applied to the criminal law. So what is it like that? If a man punished for one thing, you cannot again bring a suit and punish him again. So that is a law. There is a maxim. And interest republica utsit finis litium. So it is the interest of the state that there must be an end of the litigation. It means I am filing a suit, okay, for a possession of a property, and it didn't go with my favor, so I cannot bring a suit again for that property. So there must be an end of the litigation now. So if you filing a suit again and again for the same thing between the same parties, it is not supposed to be do. It is not desirable. You cannot do it. It is settled that once a matter is settled, you cannot bring that suit again. So there must be an end of the litigation. If there is no end, it's going on and on and on again, so it is not supposed to do. And re judicata pro vertia occupitur, judicial decision must be accepted as correct. So if a judicial things was if a judge give a verdict, it is always supposed to be a correct. If you are not happy with it, you can go for the appeal, revision, review, but not bring a suit again. So there is an object and purpose key. What is the object and purpose? The balancing the law between past and future litigation. There must be a balance between the past and future litigation, and it is based on finality. It is based on the finality, means like there must be a final decision of the matter. Res judicata is enumerated in section 11 of the Code of Civil Procedure 908. So no court shall try a suit or issue. So let's explain this whole the things. Okay, no court shall try any suit or issue. This is the one point. And a matter directly or substantially in issue is the same in a form or substantially in a case. So a court cannot try a suit or issue which is already directly or substantially in the issue in the form or substantial case. So there is two case. Okay, there is two case. It is filed for filed before. Okay, it is a formal suit. In this suit, if the subject matter is same, then on the basis of the same subject matter directly or substantially, okay, you cannot bring another separate suit. Also, there might be same parties or under whom any of them litigating. Okay, which is mean is that, like in the previous suit, A and B was the party. In second suit, if we are not party but I bring my son, like C, his son is C, he bring his C son and his bring his D son, they also cannot bring they are also be counted as the same parties. Okay, and the same title, the title must be same, like the possession title. Okay, then the two all the property subject matter is also same party, same title, and the previous suit must be judged by the competent court. If the court which previously give judgment is incompetent, that he can bring another suit. Okay, their court must be competent and heard and finally decided by such court. It is heard and finally decided, not that the suit is dismissed for for the presentation of the proper code. Okay, if a suit is plain is rejected for the presentation of the competent code, like a proper code, then it is not counted as it's adjudged. Okay, so in that matter they again can go for the same suit. And in the most important part of res judicata is its explanation. Okay, I am just given a writing in a similar way, so a simple way, so that you can just understand the core point. Okay, so in explanation, it is enumerated the formal suit. What is mean by formal suit? In second explanation, what is the competency of the court? I am coming into that matter again. So I am explaining all this point in details, but previously formally I want to know that just know the what is core point. If you understand the core point, what it is actually want to mean, that it will be ingrained in your brain and you will understand it very clearly. So in explanation 1, it is the section is explanation is explaining about the formal suit. What is formal suit? In second explanation, it competency of the parties, and second suit is a matter formal suit alleged by one party and denied by the other party. Okay, a matter is come to an issue only when a party is one party is alleging yes and other party is denying no. Second is constructive res judicata. It is very important. There is always a separate question about constructive res judicata in your question. It's always come. And second is claim not granted is refused. If a claim which is not granted, you are thought that in a formal suit the judge fails to give a verdict on a specific suit. It means that they rejected the claim or refused the claim. That's mean this is also adjudged. You cannot bring a separate suit on the basis of it again. Okay, and then write claim for one of themselves, claim for others too. It means representative suit. Okay, representative suit. And apply in execution too. It's also apply in execution. It's also there is always MCQs coming to the question coming to the examination. Exam is that whether the res judicata apply to a constructive execution proceeding. Yes, it's and last is that limited jurisdiction have a power as a competent jurisdiction, which is mean that if a court when the suit was presented, it has jurisdiction. Okay, limited jurisdiction for any reason. Okay, then the court this court lost its jurisdiction. Does not mean that that court doesn't have that competency to decide the matter. If the authority given the power to decide the matter to the court, then they have the jurisdiction, whether it is limited or absolute. If the limited jurisdiction have, that means the court is competent to decide the matter. Thus, as you can see in explanation 1, the expression formal suit shall denote a suit which has been decided prior to the suit in question, whether or not it was instituted prior thereto. Suppose two suit is instituted. One is A and another is B. Suppose B suit is priorly instituted, but A suit was given verdict before B, then A suit is counted as a former suit. Okay, next. For the purpose of this section, the competency of a court cannot be determined irrespective of the provision as to the right to appeal from the decision of the court. Competency, it's counted as a competency. For the purpose of this section means this for the purpose of this section, the competence of the court shall be determined irrespective of any provision as to the right of appeal from the decision of such court. So in this section it was saying that if a court a court has competency, does not mean that whether appeal lies to that court or not. So for the purpose of this section it will be decided. So it means that a court does not have a right to appeal. In explanation 2, it was they are saying that for the purpose of this section, competency of the court shall be determined irrespective of any provision of the right to appeal from the decision of such court. So for the purpose So the explanation 2 saying that for the purpose of this section, the competency of the court shall be determined irrespective of any provision as to the right of appeal from the decision of such a court. So which means that, for example, in this for this provision, a competency of the court shall be determined whether they have a jurisdiction or not about the whether appeal lies from it judgment or not. For example, in a small causes cases, appeals generally does not lie. Does not mean that small causes court does not have a jurisdiction or competency. Okay. Third is that matter above referred to must be former should have been alleged by one party and either denied or admitted expressly impliedly by the other party, which means that what is issue? An issue is something that alleged by one party and denied by the other party. So here it is saying that in former should, the matter means that one party which is alleging, other party was denying. And explanation 4 is constructive res judicata, which means, for example, in former suit, I was asking from B that what is constructive res judicata? Let me explain it first. A matter which might or ought to have been made a ground of defense or attack in such former suit shall be deemed to have been matter directly substantially in issue in such a suit, which is mean that, for example, I am suing Rabi for the rent of my house, for the rent of 2000 and 2002 for the whole year. But in a former suit, when I am suing him, I failed to added 2001 year. Okay. So I cannot further reopen the case or file a separate suit for the 2001 year. If I have to decide a case, then I have to make a plan for suing him. I have to add 2000 and 2000 year both year. If I am omitted such thing, I cannot later bring a further suit for the same cause of action. So if I failed something, it can be a matter of attack or defense or anything. If I omitted to do these things, I cannot later bring a separate suit on the basis of the same cause of action. Any relief, explanation 5 is saying that any relief which is not granted means it's refused. It is simple as is that. It's explanation 6, which saying that it is known about representative suit. For example, there are two party, and two party consist of lot of people. Okay, like my party, like I am plaintiff, and I am not only plaintiff, I am suing for a large group of people. Okay, for a group or an association. Okay, I'm also belong to this association. I'm suing for the group okay, hold together and to B against B, okay, and then suppose the verdict does not come into my favor, okay, my group's favor, then not again another member of this group bring a suit on the same subject of matter. So okay, it is known as representative suit, and it also apply to the representative suit. And then it's come to the execution. As I told you before, that res judicata is also applied to the execution proceeding, a matter which is the provision in this section shall apply to the proceeding for the execution for a degree, and reference in such section to any such issue or former suit shall be construed as reference respectively to the proceeding for the execution of the degree, question arising in such proceeding and former proceeding for the execution of the degree. So while the execution is going on, if something was omitted by myself, like plaintiff or defendant in whose favor the verdict is going on, if the party in execution proceeding fails to apply all this provision, okay, like he fails to bring an matter to come to the court, he will be later barred from proceeding again, okay. And explanation is limited jurisdiction, as I told you before. Again, there are court which has a limited jurisdiction, okay, in present time it has jurisdiction, but later on it loses its jurisdiction for any of reason, like you will going to in a further chapter, there are jurisdiction chapter where into transfer of jurisdiction, whether all of aspect was explained. Like for example, A is a court, which court has jurisdiction in the time of instituting the suit, okay. It loses its jurisdiction after some times due to the okay, demarcation of the demarcation of the pecuniary, demarcation of the territorial jurisdiction, okay. Like a court has jurisdiction for whole the state, okay. I'm explaining it here, okay. Like A is a court and B is a court, okay. It is a land of A, so A has a territorial jurisdiction over all this area, and B has jurisdiction over all this area, okay. And a case a C suit is instituted in A court, okay, because he was used to be situated, the property is situated of here, okay. It is a C's property, okay. This property is C's, and it was used to be A's jurisdiction, but later on, due to the demarcation of the property, okay, the property became like that, and A has only jurisdiction about this place, but B doesn't have the jurisdiction of whole this place now. So if these properties come to this B's land now, so does not mean that C A does not have competency to judge this matter, because it was it was prior to the demarcation of the property. A has jurisdiction, although A has limited jurisdiction, but A has jurisdiction and competency, and A matter will be taken to be decided at judge, okay. He later on cannot bring a suit into B's court. So thank you for till now. I am going to come again with further topic. If you like my video, please give a like and subscribe my channel. And if I cannot explain you properly, if there is any lack of something, please put it on the comment box. I try to figure it out and work on this matter, okay. So, and if you want a small short notes, okay, which give you clarity and helps you to understand the matter well, then please comment it down or follow my Instagram channel and DM there. I will send you the whole these chapters note. Thank you.